Welcome to this week's OK at Work with myself, Sarah Sawyer, and my colleague, Russell Berger, both attorneys at Offit Kurman. And today we are talking about charges of discrimination that you might receive after you've terminated an employee or from a current employee. They kind of come in some different forms, but it's a administrative process. So you'll get an administrative document saying that there's been a charge filed and giving you a certain amount of time and things to respond. And it can be a little confusing because before you've gotten a charge from the EEOC or a local agency that's related, you might not know what you're really looking at from what it is. And it was a little different than if you get sued and there's a lawsuit or something like that. So what are some things that employers should be thinking about when they get these notices, Russell, and all the mumbo jumbo? And because obviously there's the charge mixed in there, and there's instructions, and there's portals to log into, and all different sorts of things. So where do people start?
Yeah, so a good starting point is it's maybe a little less strict and formulaic, but it's still a formal, professional, it matters type of process. The way the employment discrimination laws are written, and this is true in pretty much every state, if not all the states, as well as at the federal level, is that before you can go to court on a claim of discrimination or harassment, that you have to exhaust administrative remedies, which means going through an administrative process, which is filing a charge of discrimination with the EEOC or the state equivalent. When that charge gets served on you as the employer, it's usually with a prompt that says you've got 30 days to provide a position statement, or you can engage in mediation or some sort of settlement negotiation process, depending on the jurisdiction and the agency. To fast forward a little bit, no matter what happens at the end of the administrative process, the employee will either get a right to sue letter because the agency isn't going to pursue it, or the agency might pursue it on their behalf. And that's whether you win or lose in that administrative proceedings. So you might think this is pretty inefficient. This is a lot of extra process. Why am I dealing with this? To me, that's by design. The process is designed to be burdensome and extra so that it compels people to reach resolutions on things that are relatively small claim. These often are not 6-7 figure type lawsuits. These are, I was out of work for 3 months. I was out of work for 6 months. I make $75,000 a year. We're fighting over 37 grand. From that standpoint, as an employer, I think it's important to engage and participate because one, if you don't get to a resolution, winning will put you in a better position relative to whether the employee wants to go forward with litigation in court or whether the employee's lawyer wants to go forward with litigation in court. It also creates leverage and gives you an opportunity to resolve the matter. And frankly, it's a bad look to say, I just blew it off. I didn't care.
Yeah. Yeah. And you learn a lot during that process, right? So there's whether you engage in mediation or there's an investigation, you'll learn a lot of information about what the employee is actually claiming and understanding more from their perspective, which does help you understand more about how to approach it, how there might be a resolution. Because a lot of times you'll make an assumption about what you think the employee wants or what they're concerned about. That's either from their original charge or maybe they made an internal complaint to the company before filing. But really what they're after is something that the company would be willing to do, but they just haven't been able to articulate it properly. And so a lot of times you get a lot of information. But one thing I will say about the process is definitely pack your patience because it takes time. Obviously, you mentioned some of the quick deadlines that happen right after getting a statement, and it is important to take those seriously and abide by those and engage in the process. But it's a lot of start and stop in the process. And generally speaking, depending on what the resources of the agency are at the time, those types of things, someone could go out on leave that's investigating it. And so it really varies how long these things will take, but it's a process that patience really helps, I would say.
To that point, we've had them where the government has shut down. And so the investigation stopped because the EEOC hasn't been being funded because of government shutdown. So it is a time-consuming process. But I think the important thing for the employer side to remember is that maybe that works to your advantage. And the fact that someone is looking for a financial settlement, but it's going to take time for them to get to it, might be something that gives you leverage in terms of a negotiation and can get you to a cost-effective resolution that's to your benefit.
Yeah, and also I'll say too, obviously these happen sometimes when these filings happen when someone leaves, but also someone could file one while they're still working at your company or your organization. So definitely important to come up with a plan. If you got a complaint through HR, So make sure that you've got a good plan in place to avoid any retaliation or any perception of retaliation, and making sure to find a way to maybe address the concerns that are in the complaint internally as well, if that is applicable and there needs to be anything done inside the organization while the employee is there. So that kind of adds another step. If the employee is not there anymore, that makes it a little bit easier in a sense, because obviously you're dealing with someone who's already left. But if you've got an employee who's actively there, you might have some more proactive things that you need to do to stabilize the environment.
And to broaden that out a step or two, then you might learn things that you should be doing differently. I mean, you might help you to uncover something like, hey, we can defend this claim, but maybe there's some things we could change and do better going forward, process, training, what have you. So, there's some learnings that can come from it too.
Yeah. Well, thanks, Russell. See you next time.
Thanks, Sarah.